Hello and welcome to Change India, experiments with big ideas. Today in the third show of our four-part series, we are talking about a simple but radical idea, namely apply the law of limitations to lawmaking itself. That is, every law shall compulsorily lapse and will have to be redrawn and re-promulgated. Why? Because every law is enacted in a specific political, societal or economic context. As nations evolve rapidly and the pace of change has only become more rapid, old laws can begin to hinder progress. Several Indian laws are from the 19th century, including the Indian Penal Code 1860. Most others are from the 20th century. Very few are 21st century laws.
The 129-year-old Indian Telegraph Act of 1885 still governs India's telecom and radio policy. The Medical Termination of Pregnancy Act of 1971 can be used even today to selectively abort female fetuses. The Factories Act of 1948 says that no person can spit within the premises of a factory except in the spittoons provided. And a refusal to abide by this law is punishable with a fine not exceeding 5 rupees. Section 375 of the Indian Penal Code completely dismisses marital rape. These are just 4 examples of the thousands of absurd and archaic Indian laws. With the nation evolving rapidly, archaic laws can be a hindrance to the Indian growth story. Our big idea is that every law should undergo a compulsory and time-bound review so that justice delivery in India is in sync with this day and age.
So here are our proposals. Set a time limit for the review of laws, typically between 10 to 15 years from the time of passage. 2. Begin the process of auditing the law about 18 months before the deadline for compulsory review. 3. Do the legal audit via the relevant parliamentary committee, but the use of outside expertise and public hearings should be mandatory. To debate this idea, we have on a satellite link from Delhi, Gopal Subramanian, senior advocate in the Supreme Court and a former Solicitor General of India. And in the studio, we have M.R. Madhavan, President of PRS Legislative Research, an organization that has done excellent work in monitoring the functioning of Parliament. With them, of course, is our own Dheeraj Nayyar, CEO of Network 18's Think India Foundation. Gopal, the first question to you. Is this a good idea? Is it practical? Is it doable? Is it needed?
The answers are all in the affirmative. It is imperative. It should be done. I've always believed it ought to be done. And it can be achieved. In my view, the time period is 7 years, not even 10 years. I believe audit must begin halfway down, which means 3.5 years down the line. I also believe that the audit must be undertaken by multiple institutions. You have the legal profession. You also have people from the sociological sectors of society. And of course, it must be combined ultimately by a parliamentary committee.
Now, when you say 7 years, is that practical?
I think it's perfectly practical. The first thing is all parliamentarians have to be reminded that their primary function in Parliament is also lawmaking. The amount of time which they do devote to lawmaking is disproportionately short if you look at the issues which come up for consideration. So I think the effort which PRS has done, which I think was a magnificent effort, which the Bar Council of India also collaborated for some time when I was chairman, is to take this forward. Ultimately, lawmaking must be the primary function of Parliament.
Madhavan, 7 years. We were a bit more loose with our formulation. We said 15, but 7 years is really, you're rapidly going to then turn over your laws and ensure that you are always in sync with modern societal change. Your thoughts?
Well, the idea is great. My worry is about the practical, about given the way Parliament has been functioning,
yes,
will they be able to deliver, and what happens if they don't?
Yes.
So, I would be a bit more conservative. I'll say we should maybe divide them into different types of laws, as you have suggested. And some of them may be shorter periods, some could be a longer one.
So which ones? So which ones typically would be?
So my question is simple.
Yes.
Like there are obviously, and Mr. Subramaniam knows much better than me, but things like the IPC, I just pulled out some data just to prove your point.
Right.
Section 323, which is voluntarily causing hurt, has a penalty of 1 year and or a fine of 1,000 rupees.
Right.
Okay. 334 is on provocation has 1 month or 500 rupees
Right.
if you're causing hurt.
Right.
And if you cause grievous hurt, you pay much higher amount, 2,000 rupees.
Right.
Okay. So these were possibly fairly high amounts in 1860.
They were prohibitive possibly then, but today they've become.
Okay. So there's another idea
Yes.
which especially for the monetary penalties, which is much easier to implement. So I'll try to put that into your idea.
Right.
Which is, let's say you have all the fines and you make them into 4 or 5 or 6 classes.
Right.
And then, like we have the General Classes Act, you say class A fine is this amount, class B is some other amount, C
Right.
is some other amount.
Right.
Every 10 years, you just revise what the amount for class A is. And
Right.
in the law, you're just saying fine of class A, class B.
Right.
So like in a computer program, you're passing in the variable which
Right.
can be updated much more easily. This
Right.
is definitely doable
Right.
without too much effort. That's I would say, first step.
Right.
For this, we need to really strengthen parliamentary committees.
Yes.
The way committees function today,
Yes.
I am seriously doubtful whether they have the capacity to do. They ought to have it.
Right.
They should be doing it.
Yes.
But we need to work at strengthening them.
So we'll come to that very quickly. I'll go back to Gopal and then come to Dheeraj after that. Will this require a constitutional amendment? The idea that we have, and are there any good, solid, working international precedents?
First of all, it doesn't require any constitutional amendment. In fact, the mandate of the Constitution is, if one were to interpret it in its text and spirit, is that Parliament will continuously perform its sovereign function of lawmaking to ensure equality and dignity as well as social justice at all levels. It's a continuing obligation. So there is no intervention which is required by way of constitutional amendment. The second point is, it is perfectly doable. I think the effort is that we all have to be attuned to the fact that laws must change and must change regularly. And there are precedents, by the way.
Right.
In many jurisdictions, you will find that the penal codes have changed, the law of evidence has changed, the matter of magisterial inquiries have changed, and people have given things a fresh look.
Right,
And
right.
ultimately, it is the efficient law which speaks up for your society.
Right. So Dheeraj, it's good to hear that it doesn't require a constitutional amendment. I for a moment was petrified that if it required a constitutional amendment, then the idea died even before it was born. So now that it can be done, and we seem to be optimistic here that Parliament will rise to the occasion. Your thoughts?
Yeah, I think a very good example of what we're talking about is Section 377.
Right.
Now, that is really, it's up to Parliament to look at that law, to look at that section of the law which outlaws homosexuality, criminalizes homosexuality. Now, Parliament would rather not touch it and would rather let the courts do it. So the High Court says, you read it down, the Supreme Court reversed it, now it's going to need a review petition. But the point is, this is Parliament's job. So as society changes, there are certain laws which were made in with the Victorian era, with the Victorian outlaw, which definitely need to be changed. This is one societal law, but there are economic laws. I mean, the Indian Telegraph Act, which
Right.
governs telecom, is from 1885.
Right.
I mean, in 1885, we were still talking telegraph. Now we're talking internet, mobile phones. The technology is completely changed. The ground reality has changed.
Yeah.
So how, even with amendments, how can an act which was formed in 1885 be the basis to govern modern telecommunications? It's absurd.
Right.
So I think it definitely needs to be changed, and the only way the Parliament is going to do it quite clearly is if it's forced to.
Right.
And I'm glad that it doesn't require a constitutional amendment.
So if you have a time limit, like on budget, I mean, there is a vote on account. If you don't pass it, the government cannot draw from the Consolidated Fund of India. So if you transport that spirit into almost every kind of lawmaking.
Yeah, I mean, force parliamentarians, as Mr. Subramaniam and Madhavan will both say, that their primary job is lawmaking. So why not force them to do what they're elected to do?
Okay, so there's a large amount of consensus here that this ought to be done, and of course it can be done if we actually do ensure that Parliament is made to do it. I'll take a short break at this stage, but when I come back, I want to understand from all our guests what happens if Parliament does default on a deadline. How will lawmaking then progress from there? Stay with us and come back. Welcome back to Change India, experiments with big ideas, and today we are looking at a very simple but very powerful idea, which is that every law that this country makes should have a finite life. It ends in 7 years, 10 years, 15 years, let Parliament decide that, but then the law has to be re-promulgated and therefore kept in sync with an evolving society. Gopal, picking the big pitfall here, what happens? Theoretically, what happens if Parliament has to pass a new law in year X, but it is not able to do that? Will then any action that is brought under the lapsed law, will it have to fall back on judicial precedents for the law to have teeth?
Well, I think judicial intervention will be necessary. And fortunately, under our constitution, judicial intervention is possible. Ours is the only judiciary which is empowered by constitution to fill in areas where you don't have existing laws, but by way of judicial directions, until Parliament performs its function, you can fill in the space. And it has been done very successfully. Notwithstanding criticism of judicial overreach, I would say on the whole, it has been a very worthwhile experiment. Take the case of Vishaka. Vishaka was a case which was purely by way of judicial intervention. It was much later, years later, that we have had a law today, and then of course the Verma committee sat, and we had a law in a month's time, by which we were able to amend at least about 14 sections in a criminal law. So it's perfectly possible.
Madhavan, so therefore this fear that I as a layperson had, that what happens if there is a vacuum? Gopal is clearly saying that India's judicial structure and constitutional apparatus is such that the judiciary can intervene and use precedents.
Clearly, yes. And we have had some of the sunset clauses. For example, TADA had a sunset clause, it vanished. So in some cases, yes. And I would say in cases like, let's say, land acquisition law, what happens if it lapses? You can't acquire land. Fine. Let Parliament make that you cannot acquire land. But criminal cases, what happens? Let us say the law on murder lapses. Then till the judiciary comes in, what happens in the interim? I don't know the answer to that.
But clearly if action is brought, as Gopal has said, that then the judiciary will intervene and allow...
I don't know. Let me ask Gopal whether that's possible, let's say, for a criminal law.
Okay. Gopal, question tosses to you.
Yes, Madhavan, the point is well taken. If it is a criminal law and the law is over, judiciary, even under our constitution, will not be able to revive a law which is extinct. So for criminal law, this advice will not apply. But without criminal law, if you're looking at other laws, the courts can step in.
So what happens in the case of criminal law? I know I'm probably, spending a lot of time on this point only because a lot of the skeptics are going to say this, that listen, a parliament which is not able to pass laws that are needed today, if you're going to burden it with the, with every year to pass laws which compulsorily lapse, what if it doesn't? Then what happens? What happens to a charge of murder? Can it then not be filed?
I think then the General Clauses Act comes in. Let's put it like this, that if suppose an offence has been committed, and at the time when it was committed, there was a law which was in existence, then even though the law has lapsed, the trial can continue. The case will be that whether when you don't have a law in place, a man commits that offence, can you start a prosecution? Then the answer is no.
Well, that's that obviously is a pitfall. Obviously, we are extending an argument here to a fairly sort of extreme limit. Once faced with this reality, the Parliament, of course, does pass a union budget every year, whatever be the nature of that Parliament.
Absolutely. I think right now the choice is too easy for the MPs. I mean, they don't need to do anything because they're not forced to do anything. I mean, a law which was made in 1860 is continuing today, 1885 is continuing till today, 1894 land acquisition was amended under serious pressure. So the pressure will build up once there is the prospect of a law expiring. I mean, if they say tomorrow the murder, the provision, criminal provisions for murder expire on a set date, there'll be massive pressure on Parliament to get it done in time. I mean, massive public pressure. So let's not underestimate the fact that Parliament will be forced into doing certain things. They just can't sit on it and say, sorry, today we are on holiday or we are in protest or whatever it is. So I think just because Parliament today hasn't set a great example, or in this last 5 years hasn't set a great example, doesn't mean that it shouldn't improve and won't set a better example in the future.
Absolutely. If you use a colloquial phrase, jab danda hai, then things happen in this country. Gopal, I now want to understand towards the end of this show, how will this process come into place? Now, you say no constitutional amendment is required. So, can the government simply bring in a proposal to Parliament and say, from here on, we want to introduce this provision that every law will have a finite life and will have to be compulsorily reviewed? Can it be done just by a government proposal?
Oh, yes. In fact, you will notice that every law has what's called a duration clause. And you need to have a duration clause. You can make it 7 years. I can even go along with Madhavan and make it 10 years, but it will necessarily warrant a review. And I think the very fact that you start this process once, this will be a very healthy precedent. And halfway down the line, you will have to review the working of the law.
Right.
I need to make one point here quickly,
Yes.
which is that the Law Commission which we have constituted in our country
Right.
is an executive commission. It has never been very effective, and I'm very sorry to say that government has not paid primacy to matters relating to amendments of laws. You need to have a constitutional body,
Right.
which is a Law Commission.
Right.
And it must be a body which is empowered to make repeated proposals to Parliament for changing law, and that halfway period can be even attended to by this constitutional body.
Now, quickly, a law which has got an embedded duration clause, one can understand. What about old laws which don't have any such finite embedded time in them? Under what clause or proposal or pretext can the government come in and say that we also want this to apply to all the laws that exist which don't have this embedded duration clause?
Incidentally, Madhavan and I would recollect that we made a charter of all the old archaic laws, and I thought it was the duty of a law officer like the Solicitor General and the Attorney General to have an adjunct office and look at all the old laws, immediately recommend to the government
Right.
which ones must go, which ones must stay. And if you were to ask me, that experiment will not take more than 70 days in respect of all archaic laws in India.
Madhavan?
We have had some of these experiments. For example, the FSLRC looked at a bunch of laws
Yes.
affecting markets, and they have proposed a much simpler overall lawmaking. We have had examples like the UID bill, which did not pass,
Right.
which compulsorily says that should be reviewed. It doesn't say it lapses.
Right. Right.
So it can be done to some
Right,
extent.
right. Dheeraj, running out of time very quickly.
Yeah, Raghav, I think the primary area where I would be concerned about revising laws is the economy. I think the fact of
Yes.
life in India is that 20 years after liberalization, many of our economic laws clearly predate the market economy and are not suited to the market economy, whether it's labor laws or even land laws, which were amended but not quite in a suitable way. So I think economically, if we want to achieve a growth rate of 8%, 9%, 10%, then we need things like the FSLRC, which will rationalize
Right.
financial sector laws. We need other such committees to rationalize laws in other sectors, because for a fully functional, fast-growing market economy, we need a set of laws which is not pre-91.
Right. So you've heard all our experts. This is something that the new government should take up as a challenge and ensure that our laws have this inbuilt flexibility and therefore they remain modern and in sync with the requirements of an evolving society. Thank you very much for being with us today.